Namaskar class, this is Jv'n Devashree. Awasthy. Today topic is historical school of jurisprudence. So, historical school emerged as a reaction to legal theory promoted by the analytical positivist and natural law thinker. The motto of this school is UB society is EB like, that is, where there is a society, there is a law. Sir Frederick Pollock aptly remarked that historical method is not nothing but the doctrine of evolution applied to human institutions and society. So, the historical school basically emphasizes that the historical factor influenced the origin, formation, and development of law. Law is found, not made. Law are not of universal application, as traditions and custom determine the law. Law are ruled consistently partly of social habit and partly of experience. So basically, this is good relation to legal history at large, deal with general principle of governing origin and development of law, and influence affect law. Deals in second place with origin and development of those legal conceptions and principles which are dealt differently in analytical jurisprudence. Historical jurisprudence is the history of first principle and conception of legal system. According to Professor Dice, historical school emerged as reaction against natural laws theory. So the main exponent of this school is Montesquieu. Montesquieu is regarded as the first jurist to follow the historical method. He studied the law of various societies and came to the conclusion that law are the creation of climate, local situation, accident, or imposer. Has in his book Spirit of the Law said that law school should have the basis of historical observation. That is, Monte was the first jurist who proceeded on historical method and emphasized that law of a particular nation should be determined by its national characteristic and must be relation to the climate of each country. He did not go further to explain his observation. However, this particular idea of law answering the need of time and place has been basis of many notable ideas and theories. Second, F.K. von Savny. Savny is considered to be the founder of historical school in Europe. He was academically inclined toward historical study. He was of the opinion that reforms which go against the nation's continuity are doomed. Therefore, he cautioned legislators to look before leaping into reforms. Savny believed that the nature of any legal system is a reflection of the spirit of its people. This later come to be known as every law should follow the historical course. The historical course refers to the spirit of people which manifests itself in the form of customary rules. Thus, customs are not only formal sources of law but also superior to it. Law is not only universally applicable, it varies with time and place. He rejected the theory of natural law as well as positive law. Third experiment. Sir Henry, when man studied the development of primitive societies and identified three agents of legal development. First, legal fiction. Using legal fiction, the law is changed according to the need of time while casting an impression that it is remaining uniform and constant. He stated, I employ the expression legal fiction to signify any assumption which conceals or affects to conceal the fact that rule of law has undergone alteration, its letter remain unchanged, its operation being modified. Second, equity is used to modify law as a set of principles invested with a higher scaredness than those of original law. Legislation. Finally, people came to realize that how law can simply be reformed by explicit declaration of an intention to do so and enactment of legal codes. This process was termed as legislation.